I had been on this bench long enough to know that some cases do not arrive looking dangerous. They come wrapped in paperwork so ordinary that if you blink, you miss the human damage hiding underneath. A parking citation, a municipal code issue, a small administrative dispute that should have been corrected in one decent conversation before breakfast. And then the child walks in. That is when the disguise falls away. The morning Emily Turner entered my courtroom, the room was already carrying the kind of silence that tells you people sense trouble before they can name it. Emily was 14 years old. 14. She sat at the plaintiff's table with both hands clasped tightly in her lap, shoulders rounded inward, the posture of a child who has spent too many weeks apologizing for something she never did. Beside her sat her mother, Sarah Turner, a woman with the unmistakable face of working exhaustion. Not theatrical distress, not courtroom performance, real fatigue. The kind that settles behind the eyes of women who live on schedules too full, paychecks too thin, and sleep too short to absorb one more unnecessary blow. Across from them sat Officer Daniel Price. If you glanced only once, and too casually, you might have mistaken his posture for confidence. Arms crossed, back broad against the chair, expression calm. But when you do this work, as long as I have, you learn the difference between confidence and contempt. Confidence answers questions. Contempt waits for them to finish. He had the second one. He looked at Sarah and Emily the way some people look at paperwork after a long day, something inconvenient that should have been processed quietly and disappeared. I asked the clerk to call the case. Petition involving improper citation, escalated fees, and related harassment. Sarah Turner versus Officer Daniel Price. Now, let me be clear. Judges are not supposed to enter hearings already angry. We enter attentive. We enter suspicious when necessary, but not angry. Anger clouds, listening. What sharpened me that morning was not emotion. It was the sight of a 14-year-old girl in a courtroom over a parking ticket she could not legally have caused because she was not legally allowed to drive. If that sentence sounds absurd, good, it should. Absurdity is often the first clue that laziness and authority have joined hands somewhere upstream. I asked Emily her name and age first because I wanted the room anchored in the basic truth before anybody started hiding behind procedure. Emily Turner, 14 years old. Then I asked her one simple question. Were you driving the car? No, ma'am. Were you in the driver's seat? No, ma'am. Passenger seat? Was the car running? No. Were you alone? Yes. My mom told me to lock the doors and wait. That should have been the end of the matter right there. It should have been enough to expose the stupidity of what followed. But bureaucracy has a remarkable way of surviving on momentum long after common sense has died. Sarah testified next. She worked mornings and picked up evening shifts when she could. On the night in question, she had stopped at a grocery store after a long day because the house needed milk and she needed headache medicine. The lot was crowded, the weather unpleasant, and Emily was tired. Sarah told her to stay in the car, lock the doors, and wait. It was a decision millions of parents make in 7 ordinary minutes without imagining the law might somehow be waiting outside to turn that choice into a crisis. 7 minutes. That was all. When Sarah came back, Emily was crying, the ticket was under the wiper, and Officer Price was already moving away. Emily had opened the window only enough to ask what the paper was. According to Sarah, and then according to Emily, he told her the car was standing illegally and the driver had failed to move when instructed. The driver, that word kept coming back like a bad smell. I asked Sarah what happened after that. At first, she thought it would be easy to fix. She called, explained that her daughter was 14, that the car was off, that she had only stepped inside briefly, that the sign itself was partly blocked and difficult to see from the angle where she stopped. She expected a human being somewhere in that system to hear the story and say the obvious thing. This should not have happened. Instead, the opposite happened. The ticket remained. Then late fees were added. Then administrative charges. Then, because Sarah could not pay it immediately without sacrificing something else her family needed, the amount grew. One bad act of judgment by an officer became a month-long siphon running straight into a household already stretched too far. That was when I asked the question that always matters in low-dollar cases. Not what did the paper cost? What did it cost you? Sarah took a breath and told me. The original amount was painful but manageable if she skipped enough things. The added fees were not. She fell behind. An overdraft followed when one payment hit earlier than expected. Groceries tightened. Bills shuffled. Emily overheard every conversation, every strained whisper over the kitchen table, every tired sigh after the mail arrived. The child began apologizing for all of it. She stopped drawing, stopped sleeping well, started saying she had ruined everything. That is what bad public judgment does when it lands on private families. People talk about tickets as though they are pieces of paper. They are never just paper to a household balancing on the edge of solvency. They are stress translated into mail. Then I turned to Officer Price. He said he had followed protocol. That phrase has protected more foolishness in this country than almost any other. Protocol. As though the existence of a form excuses the disappearance of a brain. I asked him to explain exactly what he thought he was doing when he wrote a citation identifying a 14-year-old passenger as the responsible driver of a parked vehicle. He said the vehicle was in a no-standing zone and had not been moved. I asked him whether he understood that a 14-year-old child could not lawfully move the car, even if she wanted to. He said the code did not reference age. That is when I knew the problem was not confusion. It was indifference. So I opened the file my staff had prepared, because by the time this case reached me, it was no longer only Sarah's word against an officer's. My researchers had done what overworked mothers cannot be expected to do between jobs and dinner and laundry. They checked citation patterns, complaint histories, body camera logs, municipal code cross-references, and what they found was not an isolated mistake. It was a pattern. Over the previous months, Officer Price had issued multiple citations in that same high-yield curb zone under circumstances that raised serious questions. A disabled mother unloading groceries while displaying a placard he later claimed not to see. A delivery driver cited while collapsing from heat exhaustion. A pregnant woman ticketed after pulling over because she became dizzy and was later transported to a hospital. In each instance, paperwork existed. In each instance, explanation followed. In each instance, the same defense appeared: procedure, volume, efficiency, the language of someone no longer seeing people, only quota opportunities. And in Emily Turner's case, the pattern deepened into something uglier. Not merely indifference, cowardice. Because children make easy targets when they have been taught to obey authority even when authority is wrong. I asked Officer Price whether he wished to reconsider his description of himself as simply following policy. He did not. Men like him often cannot imagine the floor giving way until it already has. So I laid out the evidence one piece at a time. First, the citation itself identifying a non-driver child as refusing to move the vehicle. Second, the municipal language showing discretion available to any officer with common sense. Third, the sign photographs demonstrating visibility concerns. Fourth, the complaint history revealing a striking tendency to enforce against distracted, vulnerable, and isolated individuals unlikely to mount immediate resistance. Then I asked him the only question that mattered. Did he actually speak to Emily as a child needing adult assistance? Or did he approach her only as a source of a ticket? He gave no meaningful answer because there was none to give. At that point, the courtroom understood what I understood. This was not about parking. It was about judgment, and specifically the absence of it in the one person on that curb entrusted with public authority. I turned back to Emily then, because while adults argue about procedure, children absorb blame. That is almost always the hidden emergency in cases like this. I asked her whether she thought any of this was her fault. She nodded before catching herself, which broke my heart more cleanly than tears would have. Children in trouble often cry. Children who have quietly internalized false responsibility do something worse. They apologize with their bodies before they say a word. Emily had been doing that for weeks, so I told her clearly and in front of everyone that she did nothing wrong, not one thing. She sat where her mother told her to sit. She obeyed. She waited. She did not cause a ticket. She did not cause the fees. She did not cause the fear in that house. Those belonged entirely to the adults who failed around her. The room changed when I said that. Sarah cried, not loud, the kind of crying that comes when the truth finally lands where panic has been sitting. Emily cried too, but differently. Relief has a way of looking almost painful on a child's face when she has been carrying guilt that was never hers. Then I issued my ruling. The citation was void. Every fee attached to it was void. Every collection action, processing charge, and administrative consequence triggered by that citation was void. I directed the clerk to clear the record completely. Then I made the second part of the ruling, the part that mattered beyond one family. I ordered the full file, including the complaint history and my findings from the hearing, referred to Internal Affairs and Departmental Command Review for examination of Officer Price's enforcement pattern, because a badge is not a hunting license, and public order is not maintained by selecting the vulnerable as easy paperwork. That would have been enough in many courtrooms. But enough is not always what justice requires. Sometimes justice also requires naming the moral center of the wrongdoing so nobody in the room walks away pretending the issue was technical. So I said what needed saying. Authority without common sense is dangerous. Authority without compassion is worse. And authority used against a child because the adult holding it cannot be bothered to think is contemptible. Officer Price looked smaller then, though he had not physically moved much. That happens sometimes when people realize their posture is no longer doing the work they expected from it. The room had stopped granting him the visual authority he walked in wearing. That is one of the few useful powers a courtroom still has. It can strip pretense down to conduct and leave a person standing only inside what he actually did. I do not know what happened in his department after that, beyond what the formal process allowed me to see. I know the review moved. I know the file did not disappear. And I know at least one family, Sarah and Emily Turner, got their life back from a piece of paper that should never have existed. But what stayed with me most was not his face. It was Emily's. Because here is what people who have never lived under financial pressure do not fully understand. A false ticket does not enter a struggling household as an inconvenience. It enters as weather. It changes the atmosphere in every room. It changes the way the mother sounds when she opens a bill. It changes the way a child interprets silence. It changes dinner, sleep, homework, breath. It teaches fear to spread sideways. One officer's laziness can become a child's private shame for weeks. That is why public servants are required to use judgment and not merely process. The margin for thoughtlessness is small when other people's lives are this tight. After the hearing, Sarah thanked me more times than necessary. People often do that when the system has frightened them long enough. They thank the person who stopped it, even though the system should have behaved correctly before my bench was ever needed. I accepted it because gratitude from the overburdened is often less about the judge and more about relief itself finally being allowed into the room. Emily did not say much on the way out. She just looked back once, as children do when they are trying to decide whether to trust what has just happened. I have seen that look many times. It asks a question no child should have to ask. Is it really over? This time, at least, the answer was yes. I thought about her that evening after court. Not all cases follow me home. Many should not. A judge who carries every story into the evening will become useless quickly. But some stay. The child cases stay. The ones where adults confuse their irritation for authority or their efficiency for justice. The ones where harm is small enough for the powerful to call it minor and large enough for the powerless to feel it in every corner of the week. This was one of those. I kept thinking about that phrase in the file. Driver refused to move vehicle. A line of text. Cold, neat, ordinary, and hidden inside it, a whole moral failure. A child alone in a parked car. An adult with a badge. A chance to ask one more question and choose decency. Missed. That is why I tell people that court is rarely about the paperwork alone. It is about the sentence under the sentence, the fact under the form, the human truth inside the administrative lie. If you only read the citation, this was a parking matter. If you listen to the people, it was a story about power choosing the smallest available target. No decent courtroom should ever ignore that. I've heard people complain for years that judges interfere too much, moralize too much, dig too deeply into what should be simple. Fine, let them complain. Simplicity is often just the name given by the comfortable to someone else's suffering when they do not want to think too hard about how it began. This case required thought. It required saying plainly that a child is not collateral for a parking officer's carelessness. It required telling a working mother that the law had no right to make her poorer because someone in uniform stopped thinking. And it required reminding one very smug officer that public service is not measured in the number of slips you can tuck under wipers. It is measured in judgment, in decency, in knowing when the law is meant to protect and when you are merely using it to make your own shift feel authoritative. I hope Emily remembers the sentence I gave her more than the hearing itself. You did nothing wrong. Children need those words from adults in authority because adults in authority are too often the ones who injure them first. And if you ask me what justice looked like in that room, it was not the file closing or the citation being voided, though both mattered. It was a frightened 14-year-old lifting her eyes when she heard an adult with power use that power to tell the truth instead of to distort it. That is what a bench is for, when it is worth anything at all. That is what I still believe after all these years. And that is exactly what happened. The audience that day understood it too. You can feel when a courtroom stops being a room full of strangers and becomes, for a few minutes, a single organism listening with one nervous system. People who had come for their own tickets were suddenly watching a child their daughter's age sit accused by paperwork she did not create. A delivery driver in the second row kept shaking his head. An elderly woman in a red scarf whispered, not to anyone in particular, "That poor baby." Even the clerk's hands slowed over the keyboard when Emily answered certain questions because everybody in that room knew the same thing at the same time. A child should never have had to come here to hear an adult admit the obvious. I asked Sarah more questions than lawyers usually expect in parking matters because I wanted the full path of the damage on the record. How many times had she called before she got anyone to explain the fine increase? 4. How many hours of work had she missed trying to sort it out? Nearly an entire shift if you counted the municipal office visit and the phone calls made from the back room at work. How much sleep had Emily lost? Sarah could not give me a number, but she said she started waking in the night and checking the front window, afraid some other paper might be waiting on the car in the morning. That image made the room ache, not because it was dramatic, because it was ordinary. Fear settles into rituals quickly when adults make children feel hunted. Officer Price, of course, tried to retreat to language. He said the zone was posted. He said the rule was neutral. He said signs do not discriminate between adults and minors. At one level, that is true. But discretion is the difference between law enforcement and law worship. We do not deputize machines. We deputize people because people are supposed to notice context. A running car is not the same as a dead one. A licensed adult is not the same as a frightened 14-year-old. A parent making a brief stop is not the same as someone exploiting curb space all day. Once you flatten all distinction in the name of neutrality, what you are really doing is replacing judgment with convenience. I told him exactly that. He looked offended, which interested me less than it would have years earlier. By now, I know a certain kind of officer. The kind who mistake challenge for disrespect because nobody in their immediate professional circle has made them defend the human logic of their decisions in plain language. It is not enough, I told him, to say a rule existed. I wanted to know what he saw, what he asked, what he thought, and why none of it was enough to stop his hand before the citation book came out. He kept circling back to the same barren language. Vehicle present, restricted zone, driver unavailable. I finally stopped him and said, the driver was not unavailable. The driver did not exist. What existed was a child. The room went perfectly still after that. My staff had also prepared a short municipal summary showing alternatives available to officers in situations involving unattended minors. Welfare check, inquiry, temporary warning notation, escalation to a supervisor if necessary. In other words, there were at least 4 ways to respond before ever considering a citation. He had chosen the one that punished the family fastest and required him to think the least. That, too, is a kind of character. There are moments from the bench when you can see a witness or a party realize that the moral story they have been telling themselves is beginning to collapse. It happened to him slowly, not all at once. First, the shoulders stiffened, then the jaw tightened. Then the eyes stopped doing that lazy, drifting thing and began fixing on very specific points in front of him, as though concentration itself might rebuild credibility. But credibility, once spent on a child, is hard to recover. I also want to say something about Sarah Turner, because mothers like her are easy to overlook in public systems. She did not arrive in some heroic glow. She arrived tired, worried about missing work, embarrassed to be in court over something this ridiculous, and deeply afraid that if she said the wrong thing, she might somehow make it worse for her daughter. That is how many decent people experience institutions, not as places built for them, but as rooms where one wrong sentence might cost them more. The powerful do not enter rooms that way. They enter assuming they will be understood. The burden on the poor is often not only to be right, but to present rightness in an acceptable voice. Sarah did that beautifully, and she should never have had to. After I ruled, I asked the clerk to remain seated for a minute before calling the next matter. Some judges do not like pauses because pauses break flow. I have learned that pauses preserve dignity. Emily and Sarah needed a minute to gather themselves without feeling hustled out for administrative efficiency. So they stayed. Sarah cried. Emily wiped her face. The bailiff, who had been very still throughout, brought them tissues without being asked. Small decencies count. A courthouse is remembered not only for the major ruling, but for the minor mercies. Later that week, I asked Chambers to confirm that every related fee had truly been removed and that no automated billing notice would regenerate from a lazy system overnight. You would be surprised how often clerical ghosts continue haunting a family, even after a judge has spoken plainly. We confirmed the account was cleared, the citation vacated, and the collections note withdrawn. I also asked that the family be sent written confirmation in ordinary language. Not bureaucratic language, ordinary language, because people deserve letters they can understand without needing 3 phone calls and a dictionary. A month later, Sarah sent a short note. Nothing ornate, just a thank you and one update. Emily had started drawing again. That sentence sat on my desk for longer than it needed to. Started drawing again. There it was, the whole case reduced to what mattered most. A child who had briefly stopped being a child because adults in authority made her feel dangerous was returning to herself. That is the kind of outcome no statistical report can adequately measure. I do not tell these stories because I enjoy condemning public servants. Most of them work hard. Most of them are underpaid, overburdened, and trying to maintain order in systems designed by people who rarely have to stand in the weather. But all the more reason to speak clearly when one of them forgets what the badge is for. Public service depends on trust. Trust depends on judgment. And judgment depends on never confusing a vulnerable person with an easy target. So if you ask me what made this case memorable, it was not complexity. It was clarity. One child, one mother, one officer, one absurd ticket, one chance for the court to either participate in the madness or stop it. I stopped it. And that is why I still believe in the bench when it is used properly. Not because robes are impressive, not because gavels make noise, but because every so often, a frightened person comes into the room carrying a lie some institution has told about them, and the law, if it is functioning at all, gets to answer back. No, that child is not the problem. No, that family will not carry this burden one day longer. No, a badge does not turn indifference into wisdom. That is justice in its plain clothes. And on that morning, plain justice was exactly what Emily Turner deserved.